Assalamualaikum and a very good afternoon to Dr. Emma, fellow friends. We are from Group 6. We'll present the last topic for this course, which is the stamp duty. This is the list of the sections under the Stamp Act 1949 that was stated in this presentation for your reference. For this topic, me and my group members will cover on the introduction, general principles, instruments not duly stamped, allowance for spot stamps, and penalties. As the first presenter, my name is Faikdini Biarmansyah, Meljuk number 273293, and I'll be presenting on the introduction and the general principles on the doctrine form of substance. So first of all, do you guys know where and when did the stamp duty exist? So stamp duty were actually originated and was first introduced in England back in the year 1694 as a transaction tax, and were designed to raise money in the war against France during that time. Stamp duty was originally applied to a limited range of goods, but later it was expanded to cover all manner of weird and wonderful products such as hats, gloves, lottery tickets, newspapers, pamphlets, adverts, perfumes, and even hair powder. After less than a decade since the implementation of stamp duty in England, the country were reportedly generating profit of 91,206 Great Britain pound from the stamp duty, which approximate to 54.71 million ringgit Malaysia in the year 1702-1703. So, due to its ability to raise funds for the government, stamp duty has been an important foundation until today. Next, we will see how is the stamp duty were introduced in Malaysia. So, stamp duty was first introduced and legislated in Malaysia in the year 1949 under the first schedule of Stamp Duty Act 1949. Stamp duty was one of the elements of colonial processes that was adopted by Malaysia through the British common law, that comprises one of the two pillars of Malaysia's justice system until today. In Malaysia, stamp duty are imposed on the instruments as specified in the first schedule of Stamp Act 1949. Unlike England, the stamp duty are not imposed on transactions with effect from 1 October 1989. The Act is applicable throughout Malaysia, where the duty imposed may be divided into two types, which are fixed duty and ad valorem duty. Fixed duty is a duty that is fixed at a sum which does not differ with the value of transaction, while ad valorem duty is a duty that is varies depending on the type and value of the transaction as specified in the instruments. Done with a brief history about stamp duty, now let's move on to the next part, which is the administrative organization. You guys must have wondered who is in charge to manage the stamp duty. Well, the stamp duty were managed by the collectors, which consists of the collector and the deputy collector of the stamp duty. So the Director General of Inland Revenue shall be the collector of stamp duty. Meanwhile, the deputy collector were appointed by the Ministry of Finance. So, what power do the collectors have? According to the Section 3A of the Stamp Act 1949, the first power is by issuing a written notice to any person to produce any instruments for the purpose of ascertaining whether it is chargeable with duty and whether that duty has been paid. Second, having a full and free access on all lands, buildings, places, books, and documents. Third, having a power to possess such books and documents. Fourth, they may authorize any valuer employed by the government, public or private. And lastly, the collectors can charge any person less than 250 ringgit if the person obstructs the work of collector. Next, we move on to the comparative bill of stamp duty in relation to other taxes. In this part, I will explain about the differences of stamp duty with other taxes such as income tax, real property gain tax (RPGT), and sales and service tax (SST) in terms of definition, basis of charge, chargeable person, and rates. Firstly, in terms of definition, stamp duty is a tax on stamping legal documents or instrument. Income tax were defined as a tax on income derived from Malaysia or received in Malaysia. Meanwhile, RPGT is a tax on gain or profit derived from disposal of Malaysian real properties, and SST is a single-stage tax charged on a manufacturer or importer and service provider. For basis of charge, stamp duty is charged on the amount specified in the instruments. Then, income tax is charged on income derived or received in Malaysia. Meanwhile, RPGT is charged on chargeable gains from disposal of real properties in Malaysia. And SST is charged on taxable goods manufactured or imported and on services rendered. Next, for chargeable person, stamp duty is charged on person payable based on the type of instruments as listed in third schedule. For income tax, it is charged on individuals and corporations. Meanwhile, RPGT is charged on a company, partnership, a body of persons, and corporation sole. And SST is charged on the manufacturer and importer for the sales tax and is charged on consumers for service tax. In terms of rates, stamp duty is taxed between 1% until 4%, for income tax is taxed between 0% until 30%, and for RPGT is taxed between 5% until 30%, meanwhile SST is taxed between 5% until 10% for sales tax and 6% for service tax. Okay, so this is an additional information. The last term is the collection from the 4 different types of taxes. According to the source of Ministry of Finance, in the year 2021, it was reported that stamp duty generated 6.2 billion ringgit. For income tax, it generated 111.8 billion ringgit. Meanwhile, RPGT generated 1.8 billion ringgit, and lastly for SST, it generated 5.3 billion ringgit and 8.9 billion ringgit for both local and import of sales tax respectively, and 12.3 billion ringgit for service tax. Next, we move on to the structure of Stamp Ordinance 1949. It was first enacted in 1964 and revised in 1989, which consists of 10 parts. It also consists 52 amendments with more than 80 sections amended and added. The latest amendment is in 2014. After we have done with the introduction of the stamp duty, now we move to the general principle of stamp duty. It consists of 9 principles which will be explained by me and my group members. So the first principle is the doctrine of form and substance. The substance of a form can be referred to determine the need to examine the substances of the agreement or document rather than the form. The scope and amount of stamp duty levied on the instrument determined by the examination of the true meaning of the substances and not the description of the instrument, which is the form. The substances of a form is to supply stamp duty in the classification of instrument. It is also usually invoked by courts due to the taxpayer playing a scheme of transactional relationship solely to gain tax benefit. If the tax motivation outweighs the transaction business purpose and profit goal, the court will decide that the form, which is the written contract, does not reflect accurately the substances if the agreement, thus the intended tax benefit will be denied by the court. Next, we will move on with the cases that related under the doctrine of form and substance. The first case is about Eastern National Omnibus Company versus IRC 1939. So the case is about a bus company service which selling buses to other companies. Then they withdraw their services for the particular area, and in return, bank receive a monetary payment and occur in an agreement with the company. So the issue for this case is whether the agreement is payable to stamp duty. Thus, after looking at the substances of the agreement, it was held that the agreement was for sale of goodwill. Hence, the agreement is payable to ad valorem duty. The second case is about Tay Gyok Yap and Anor versus Commissioner of Stamps Singapore 1966. On the death of the deceased person, the letter of administration had been granted to the deceased principal's wife and his son. Subsequently, a claim was made by the deceased lawful widow, and High Court found that she was the lawful widow of the deceased and ordered the letter of administration to be granted to her and the other widow and her son. After that, the parties entered into a deed of agreement where the lawful widow received 220,000 Singapore dollars in consideration of renouncing all her right to the estate. The deed was presented for assessment of stamp duty, and Commissioner of Stamps certified that the deed was chargeable with ad valorem duty. After that, the appellant was dissatisfied with the assessment and appealed to the court. So the issue in this case is whether the deed of agreement chargeable to stamp duty. Thus, it was held that the deed of agreement was a conveyance on sale and attracted ad valorem duty. Therefore, the deed of agreement was chargeable with stamp duty. The third case under this principle is Malayan Palm Oil Bulking Company Limited versus Commissioner of Stamps Singapore 1940. The case is about a document described as a core license was presented to the Commissioner of Stamps for stamping purpose, and the stamp fee of 5 Singapore dollars was tendered. The Commissioner of Stamps has an opinion that the document amounted to a lease and agreement under sale. Thus, the Commissioner of Stamps certified that the proper stamp duty is 101 Singapore dollars, basing his assessment on the ground that the lease was for a period exceeding 3 years at annual rent at 6,000 Singapore dollars and certain charges of pumping oil. The document was stated to be a supplemental of 2 licenses, where each license with a rent of 6,000 Singapore dollars. Thus, the issue in this case is whether the stamp duty assessment adopted was correct. Hence, it was held that on the true construction of the document, it was a lease. Thus, the assessment adopted by the Commissioner was correct. Lastly, the case related with this principle is Lima Asphalt Paving Company versus Commissioner of Inland Revenue. This case is about a company agreed by indenture to ship asphalt from Germany and to sell it to the taxpayer Hetherington, at the same time covenanting to grant to him the sole and exclusive right to use and sell the asphalt in 2 English counties for a specified period of time. So the issue in this case is whether the stamp duty will be imposed to the instrument or not. Thus, it was held that as regards that covenant conferring the sole right to use the asphalt, the indenture or the document did not amount to conveyance or transfer of property. Hence, according to the Judge Martin B., it is important to know that the real and true meaning of the instrument in order to determine whether the stamp duty will be chargeable upon that instrument, and if yes, to what amount the stamp duty payable will be. And that's all from me. I will pass to the next presenter. Thank you.
Assalamualaikum and hi, my name is Farah Zulfa bint Uthman, metro number 272953. I will present about the 10.2.2 stamp duty on instrument, not transaction. Stamp duties are imposed on instrument and not transaction. An instrument is defined as any written document, and in general, stamp duty is levied on legal, commercial and financial instruments. Example of the instruments subjected to stamp duty are real property transfer, share transfer, business transfer, rental or lease, and securities. We can see to the case Lim Tek Lee versus the Commissioner of Stamp 1956. Okay, the issue is whether chargeable as a partition of partnership property or receive a conveyance on sale or an agreement for sale. Okay, the fact is several persons trading in partnership under the firm's name of Lim Tek Lee were registered proprietors of a trademark. On the retirement of a partner, the remaining members of the firm applied for registration of the trademark in their names. In support of the application, they produced an instrument reading I sell and Hua acknowledged receipt of $185 Singapore in full satisfaction of my share in the capital asset and goodwill of the partnership of Lim Tek Lee. I confirm that as a result of this payment, I cease to be a partner in the firm with effect from 31st of December 1951, and that the continuing partners are solely entitled to all the assets of the firm, including the benefits of all trademark, goodwill, furnitures. I acknowledge that as at the date hereof, I am indebted to the said partnership firms in 118,000 Singapore dollar, and I undertake to pay the said sums forthwith. The instrument was stamped as a receipt with 6 cents. Health. The instrument in the case was not a mere receipt, but was in effect a transfer of the retiring partner's share in the partnership assets to the continuing partners for 185 Singapore dollar, and therefore it was in equity a conveyance for sale and therefore chargeable with ad valorem duty. The Commissioner of Stamp charged it to be chargeable with ad valorem duty, and this was affirmed by the High Court, the firm's appeals. Next, we can see the case of BASF Service M. Sunil Berhad versus Pemungut Duty Stamp 2010. Okay, the issue is whether the infrastructure fees is part and parcel of the consideration in the transfer instrument and as such attracts stamp duty. The fact is, on the 11th October 1997, the appellants BASF purchased property in Pahang from Perbadanan Kemajuan Negeri Pahang (PKNI). There were the components to the agreement: the purchase price, the development fees, and the infrastructure fees. Total is 170,645,250 ringgit. Okay, the appellant state only the purchase price and omitted the development fees and the infrastructure fees as part of the consideration transfer forms. The collectors assess the stamp duty on the aggregate contractual sums of the three components. The High Court held that only the purchase price and development fee should be taken in the assessment of stamp duty, and the collector's assessment was set aside. The collectors then appealed to the Court of Appeal and was successful in the whole sums of 170,645,250 ringgit was held to be assessable. BASF then appealed to the Federal Court. The help is the High Court had erred in law and in fact in holding that stamp duty cannot be imposed on the infrastructure fees, as stamp duty is imposed on the instrument and not the transaction. Okay, next is 10.2.3 Leading and Principal Object. Principal instrument, stamp duty subject to what prescribed in the first schedule. Subsidiary instrument, duty subject to fixed duty of 10 ringgit. Section 4.3, where in the case of sale, lease, charge, settlement, exchange or partitions, several instruments are employed for completing the transaction. The principal instrument only should be chargeable with the duty prescribed in the first schedule for the conveyance, lease, charge, settlement, or partition, and each of the other instruments should be chargeable with a duty of 10 ringgit only, and the parties may determine for themselves which of the instruments so employed should, for the purpose of this subsection, be deemed to be the principal instrument. Okay, we can refer to the case of Lima Asphalt Paving Co. v. IRC. Okay, the issue is whether the stamp duty will be imposed on the instrument or not. The fact is, a company agreed by indentures to ship asphalt from Germany and to sell it to the taxpayer, had gone at the same time convening to grant to him the sole and exclusive right to use and sell the asphalt in two English countries for a specific period of times. The help is, stamp duty is chargeable upon an instrument. The legal rule is that the real and true meaning of the instrument is to be ascertained, that the description of it given in the instrument itself by the parties is immaterial, even though there may have believed that its effect and operation was to create a security mentioned in the Stamp Act, and they so declared. Okay, we can refer to the case of Chia Chung Kan and others versus Registrar of Title Kedah. The issue is whether the taxpayer was also exempted from being liable to ad valorem stamp duty under item 32A, Schedule 1 of the Stamp Act on the Memorandum of Transfer (MOT) for the transfer of land which was part of the sale of business agreement (SBA) if the SBA is exempted pursuant to the Section 51 of the Stamp Act 1949. The fact is, 7 applicants brought appeals of land and become the co-proprietors to the land. There was partition agreement made to subdivide the land into 7 lots. All 7 applicants in line with partition agreement applied for the cross transfer by means of 3 memoranda. The solicitors request collectors to value the land separately as described in memoranda transfer. The collector valued the land of 7.2 thousand ringgit, 6.2 thousand ringgit, and 55.6 thousand ringgit. The solicitors then had the memorandum for stamp. The highest value of the memorandum is 70.2 thousand ringgit was stamped with ad valorem duty, while the remaining to stamp with 50 cents stamp duty value at that time. When the memorandum were presented to be registered, the collector accepted only the remaining 2 were not stamped properly. The appellants argue that this memorandum is case of exchange which can be assessed with scope of Section 4.3 of Stamp Act 1949. The help is, if a contended by the collector of stamp duties that the exemption under Section 51 of the Stamp Act 1949 SA was only for the primary instrument and not the MOT, which is a subsidiary instrument to complete the undertaking, then by virtue of Section 43 of the SA. The MOT was also exempted from stamp duty, where the document were also exempted. Next is 10.2.4, the separate and distinct matter rule. If one single instrument are related to several distinct matters, then it will be subject to stamp duty as separate instruments. No duty evasions can be made by incorporating the instrument as one. Section 6b states that any instrument that has been stamped with ad valorem but involves separate matters will be charged further. In the sections of 10.1 stated that stamps that appear on one instrument cannot be used for another instrument. Section 10.2 states that if two or more instruments are written on one piece of paper, it must stamp separately. We can refer to the case of Fitch-Lavelle Limited versus Inland Revenue Commissioners 1962. Okay, the issue is whether sale and purchase agreement related to these two matters. The fact is IBS was a company incorporated under Companies Act and their shares were dealt with the London Stock Exchange. Fitch-Lavelle Limited acquired IBS share and then sold it to its subsidiary company, Lavelle and Christmas. There was a written sale and purchase agreement. The help is there are two different methods written on one agreement. Therefore, the instrument should be stamped separately because it involves distinct matters. Okay, next we see to 10.2.5. Liability under two heads of charge. This involves a statement of liability of standard instruments where an instrument is liable to stamp duty within two different categories or heads. It is provided that distinct matters, including separate consideration, should be separately charged. Okay, we refer to the section 6. Except where express provisions to the contrary is made by this act or by any other written law. A. An instrument containing or relating to several distinct matters should be separately and distinctly charged, as if it were a separate instrument with duty in respect of each of the matters. Okay, B. An instrument made for any consideration in respect of which it is chargeable with ad valorem duty, and also for any further or other valuable consideration or considerations, should be separately and distinctly charged, as if it were a separate instrument with duty in respect of each of the consideration. Refer to the case of Stanway Limited versus collector of stamp duties, IPO. The issue is whether the instrument is liable to stamp duty within two different categories or heads. Okay, the fact is Stanway Good Limited and Stanway Limited agreed to sell and purchase several assets listed on the agreement made. Okay, the assets were sold at the 1st January 1931. From this date, purchasers eligible to receive profit. Collector of stamp duties assessed the agreement made that it was a conveyance on sale, so that stamp duty payable is $1,772.70. Okay, the purchaser argued that the agreement is not conveyance on sales. Okay, the help is the agreement is not a conveyance on sale, but it's just an agreement between the parties to give the purchasers an assurance that they have become the owner of the asset, but not title pass. So stamp duty amounted to $1,772.70 is not relevant. It should be only 25 cents. In the case of spread brother appearance and commissioners of inland revenue respondent, the issue is whether the document is chargeable with duty under two categories. The fact is, this is about the United States of Mexico issue gold coupons treasury notes with a promise to pay principal and interest to bearer at fixed date either abroad or at the option of the holder in London. The documents come within each of two categories chargeable with duty stamp at 1949. The help is the document contains a promise to pay and is therefore in legal physiology a promissory notes. The instrument fall within both of the categories in the Taxing Act. Okay, the Crown is entitled to only one of the duties, but it may choose the higher. The result was that it may be assessed on the other class at the option of the government.
Hi and Assalamualaikum. My name is Nur Ain Hamizah binti Muhammad Halim and my number is 273658. I'm going to continue the presentations to talk about the contingency principles at 10.2.6. This principle is applied when it is not possible to determine the consideration at the time the relevant instrument is executed. All the contingency will be ignored, and if the relevant instrument sets a maximum limit for the consideration, the stamp duty will be payable on this amount. Yet, the minimum amount set will be taken as a consideration payable when there's no maximum amount is stated. The consideration will be expressed in three ways, which is expressed in a formula, in a reference to a benchmark figure, and according to relevant case of law. Next, I'm going to continue about the case of Coventry City Council versus Inland Revenue Commissioner, 1977. The issue is whether the contingency principle is applied. The fact of the case is about an under lease at an annual rent, which include a sum which was to be equivalent of 8.1.142 of the total expenditure of the underlessor up to but not exceed 1,300,000. The duty held of the case is the duty was properly assessed on the basis that a sum of the equivalent times the total expenditure was included as a part of the annual rent. Looking at another cases of LM tenancy PLC versus Inland Revenue Commissioner 1996, the fact is about a tenant were granted with two lease dated 14 August 1993. The lease need the payment of premium calculated with formula A plus A times with B. The formula is based on the specific amount and the price of the certain stock at 25 business days after execution. The formula is to make the premium for the lease uncertainable, and there's no stamp duty payable. The help for the case is the duty was to be calculated by the reference to the price of the loan stock prevailing as at the date of the grant, which result the ad valorem duty was payable. The next part is about the liability that based on the fact that existing at the date of the instrument. This is according with Section 5 of Stamp Act 1949 about all the facts and circumstances affected liability of any instrument to duty or the amount of duty which any instrument is chargeable are to be fully and truly set forth in the instrument, and the collector may require such evidence to be furnished as may be reasonable necessary to prove that all such facts and circumstances are truly set forth. Next is about the valuation of the duty. According to Section 12A of Stamp Act 1949, where an instrument is chargeable with duty under item 32A of the first schedule, the date for determining the market value of any property being transferred, settled, or gift shall be as follows. On the first case of the settlement or gift, the date will be on the execution of the instrument of trust, settlement, or gift. The second case is about a transfer implementing a sales under a duty stamp agreement for sale and purchase. The date will be on the execution of the agreement. The third cases is about a transfer of any property granted by a statutory body, a local authority, or any cooperative society registered under any law relating to cooperative society, the date when the final terms of transfer been communicated to transfer in the case of subsequent resale of that property. The date will be on the consent by statutory body or local authority or the board of the cooperative society for that resale. The next case is about a transfer under a duly stamped sales and any purchase agreement where financial agreement have been made in accordance with the Sharia. The date of execution for the execution will be as per agreement. And for another case, the date of execution of the the date is when the execution of instrument of transfer made. Looking at the case of Chin Choi and other versus the collector of stamp duty, the issue is whether the stamp duty is executed at the right valuations. The fact of the case is appeal. This is an appeal from the decision of Federal Court. On 30th October 1971, the property was agreed to be sold by sales and purchase agreement. The purchase price is 49,000, and on 26 June 1973, the memorandum of transfer was executed and the market value was 65,000. The collector assessed stamp duty is up to 65,000 on the market value, and the appellant dissatisfied with the appeal of an appeal for the case. The court held that to dismiss the appeal because there is no ambiguity in the word execute and in context with Section 12A. The next case is about the collector of stamp duties versus Ng Fah In and others. The issue is whether the land is valued correctly. And the fact for the case is the first respondent sold certain land in Temerloh Pahang to other respondents for 20,000. The memorandum of transfer was sent to the collector, but the collector refused, and then it sends a inquiry and report to valuation officer. The valuation officer give the value of the land as 12,000 per acre. The collector of the stamp duty rely on the valuation officer's reports, and the stamp duty payable was 1,452 ringgit. The respondent asked the collector to state cases for the opinion of the High Court. The court held that the valuation of the land was only 3,000 per acre, and the duty was accordingly to be reduced and excess to be refunded after consider the evidence and the submission of the counsel. The next case is about the BASF service Sdn Bhd versus Pemungut Duty Stamp on 2010. The issue is whether the infrastructure fee are part of the consideration for the agreement and hence liable under Item 32A of the first schedule to the Stamp Act 1949. The fact of the case is on 11 October 1997, the appellant BASF purchased the property in Pahang for Perbadanan Kemajuan Negeri Pahang. There was three components to the agreement: the purchase price, development fees, and infrastructure fees. The appellant stated only the purchase price and omitted the development fees and infrastructure fee as part of the consideration for transfer form. The collector assessed that the stamp duty on the agreed contractual sums of the three components. The High Court held that only the purchase price and the development fees should be taken in the assessment of stamp duty, and the collector assessment was set aside. The collector then appeal to the Court of Appeal and was successful in the whole sum of 90 was held to be accessible. BASF then appealed to the federal court. The court held that the federal court is dismissed the appeal by BASF. The next part is about the payment of the duty. According to Section 7 of Stamp Act 1949, all duties which any instrument are chargeable under this Act shall be paid, and the payment shall be indicated on such instrument by A. means of an adhesive stamp, B. affixing an official stamp to such instrument, or attaching a stamp certificate to such instrument. Payment of duty may be made at LHDN office in the following way. If the duty is less than 100, it can be made by cash, and it can be made by revenue stamp if the duty is less than 500. The other way is by the money order, solicitor checks, or bank draft made payable to the collector of stamp duty, and need to submit relevant instrument to be stamped duty office by hand or through registered post. The method used to pay stamp is stamp certificate, which is a stamp application is done online via internet at the LHDNM website, or it could be the second method of impress stamp with this digital Franklin machine. It's according to Section 8 of Stamp Act 1949. Or the third way is by revenue stamp hasil, and the fourth way is a compound duty, is according to Section 9 of Stamp Act 1949, and the last way is by official receipt. Next part I'm going to talk about is about the procedure for the valuation. We need to consider basis of the tax as provided under first schedule of Stamp Act 1949. This duty is based on the money value of the consideration or market value of the property, whichever is greater. And the date for valuation is where there is a sale or purchase agreement of the date. The date of valuation is the date of execution of the agreement. Otherwise, it will be on the date of execution of the instrument of transfer. The rate is subject to the first schedule of Stamp Act 1949, which is on the first 1,000 is 1%, and any amount in exceeds of 100,000 but not exceeding 500,000 is 2%, and any amount in excess of 500,000 is 3%, and any amount that excess of 1 million is 4%. This is amended in a budget 2019. That's all from me, and thank you.
Assalamualaikum and greetings everyone. My name is Khairul Izwan Kamaruzaman, matrix number 261104, and I'll continue with the instrument not duly stamped. Okay, the first one is regarding the examination and impounding. So in the section 51 subsection 1 mentioned that every person with legal or party consented power to accept evidence, and every person in charge of public office, excluding the police officer, must impound any duty charge instrument that is not properly stamped. Okay, following that section, section 51 subsection 2 mentioned that every person must inspect every charge instrument produced or brought before him, whether it has properly stamped of the value and description required by the Malaysian law when the instrument was performed or initially executed. Then nothing herein shall be regarded to require any magistrate or judge to examine or impound if he or she ever does things it do not fit to do so any indicator coming before him in the course of any criminal proceeding. Then, in the case of a High Court judge, the registrar will shall examine and impound any instrument under this section. Okay, so following that, we can refer to the case of Arbiah versus Azinol, where the issue in this case is who should pay the duty and the penalty as the document is unstamped and impounded. So, the fact in this case is that the respondent is contracted to build a house for the defendant, and they have entered into several agreements. Then, in the case, the common ground of that is that the document was chargeable to be stamped, but the document was unstamped at all and then impounded. So, in the court below, the late President applying Section 51 and 52 Stamp Ordinance 1949 and considered that the document was inadmissible as evidence and only function as the introductory background without considering any of its content. So the defendant applied to the High Court the notice of motion to impound the document as it will be usable after the payment of the duty and the penalty. So in the case of Arbiah versus Azinol, the court held that the document should normally be stamped before or at the time of execution, but it also could be stamped after the payment of the stamp duty and also the execution. So in the circumstances, the defendant is the one should pay the whole amount of the penalty and also the duty. Next, we go to the next one, which is the instrument not duly stamped inadmissible in evidence. So in the instrument not duly stamped inadmissible as evidence is mentioned under the section 52 subsection 1, where it's mentioned that no instrument chargeable with any instrument chargeable with duty shall be admitted in evidence for any purpose by law or by the consent of party of authorities to be admissible as evidence unless such instrument is duly stamped, where section 52 subsection 1 subsection A also any such instrument shall, subject to all just exceptions, be admitted in evidence on payment of the duty and the penalty, if any, chargeable in respect thereof under section 43 or 47A. 52 subsection 1B also mentioned that nothing herein contained shall prevent the admission of any instrument in evidence in any criminal court, and C, nothing herein contained shall prevent the admission of any instrument in evidence of any court when such instrument has been executed or on behalf by the government of Malaysia, of any state or government of any other country, or where it bears the certificate of the collector as provided by this Act. Next, in section 52 subsection 2 also mentioned that no instrument executed outside Malaysia or relating to property in Malaysia or a matter done or to be done in Malaysia shall, except in the circumstances mentioned in subsection 1, which be given in evidence or referred to or used in any proceedings in any court or before any tribunal, board, commission, committee or similar body established under any written law, unless it is duly stamped in accordance with the law. Section 52 subsection 3 also mentioned that in the subsection 2, part of Malaysia includes any territory which is part of Malaysia at the time of the proceedings, notwithstanding that it was not part of Malaysia when the instrument is executed. Okay, for section 52, we can refer to the case of Alagapa Cetia versus Freedom Shah bin Cik Yam. So in the case, the issue was whether both memorandums are admissible as evidence. The fact of the issue, as an individual borrow money from a money lender using his share in a certain land as a security. The memorandum agreement and a memorandum of charge were executed. However, the individual failed to repay the loan and the money lender applied for an order to sell his share of the land. So the individual argued that he did not receive an authenticated copy of the memorandum of agreement, and then the claim for the repayment of the loan was statute bar and the memorandum of agreement was not properly stamped. So in the case of Alagapa Cetaya versus Freedom Shah bin Yam, the court held that the memorandum does not have to be stamped as it was not a promissory note. Both the memorandum were inseparable and such as date as the loan was not emitted. So the memorandum of agreement had clearly provided the interest and the charge was in fact executed. The next case that we can refer for the section 52 is the case of Shah Hamid versus Mustafa, where the issue is the stamp on the document had not been cancelled and deemed to be unstamped, which is inadmissible as evidence. The issue is this was an election petition in which it was prayed that it be determined that the respondent was not duly elected as the member of the parliamentary constituency Tanah Merah Kelantan to the Dewan Rakyat. So the main ground for the petition is that the statutory declaration by the respondent, which is the nomination papers, was invalid as the stamp on it had not been cancelled in prescribed manner. So therefore the returning officer was wrong in accepting the nomination papers of the respondent. So in this case, the court held as the stamp on the statutory declaration had not been cancelled in the prescribed manner, the statutory declaration must be deemed to be unstamped and also therefore it inadmissible in evidence and could not be acted as on for any purposes. As there were no valid statutory declaration, the returning officer should have rejected the respondent's nomination paper, and as this case was a non-compliance with provisions of the regulations relating to the election. So the next one is the agreement evidence by letters not duly stamped, where the section 55 mentioned that one is where a contract or agreement of any kind is affected by the correspondence consisting of two or more letters. So any one of the letters bears the proper stamp, so the contract agreement shall be deemed as duly stamped. Then number 2 is where the agreement is evidenced by one or more letters between parties which the letters were not stamped before it being used, shall be lawful for the collector on being satisfied that the omission to have the letter or letters did not arise with the intention to evade the proper stamp duty payment, and also to affix proper stamp on the stamp letter or any one of the letters, and evidencing the contract on payment of the duty and a further duty of 10 ringgit by the adjudication fee. And then the third one is the on stamping letter of under this section, the collector shall write his name, the word duly stamp, and shall add at his signatures or initials thereto, and also the day, month, and the year on which the letter was stamped. And for the fourth one is where a letter is so stamped, all the letters forming together the agreements may be used in evidence to prove the agreement stated properly or partly stated in the letter so stamped.
Thank you, my friend. Now I will continue this presentation with the recovery of duty. My name is Siti Nabila binti Muhammad Roslan and my matrix number is 270702. According to Stamp Act 1949, Section 56, recovery of duty is when any duty or penalty has been paid in respect of any instrument by any person, any by agreement or under this Act, or of any other written law in force at the time when such instrument was executed or first executed. Some other person was liable to pay the duty on such instrument. The first mentioned person shall be entitled to recover from such other person the amount of the duty or penalty so paid, and for the purpose of such recovery, any certificate granted in respect of such instrument by the collector shall be inconclusive evidence as to the amount of the duty and penalty paid, and the person by whom they were paid. As for the allowance for spoil stamp, according to Section 57, it is subjected to any rules which may be made under this Act and to the production of such evidence by statutory declaration or otherwise as the collector may require. Allowance shall be made by the collector for stamp spoil in the following cases. Firstly, any paper whose stamp is accidentally and unintentionally spoiled, erased, or otherwise made unfit for its original purpose before its carry a signature or is executed by any party. Secondly, the stamp on any promissory note signed by or on behalf of the maker has not been used or delivered out of his hand in any way. Next, any adhesive stamp which has been inadvertently and undesigned, spoiled or rendered unfit for use and has not, in the opinion of the collector, been affixed to any paper. And lastly, the stamp on any promissory notes that has been ruined or rendered useless by omission or error, even if it has been given to the payee, provided another complete and duly stamped promissory note is produced identical in every respect but for the error and omission with the spoiled note. Next, according Section 58, allowance for misuse stamp, when any person has inadvertently used for an instrument liable to duty a stamp of greater value than was necessary, or has inadvertently used a stamp for an instrument not liable to any duty, the collector may, on application made within 12 months after the date of the instrument, or if it is not date, within 12 months after the execution thereof by the person by whom it was first or alone executed, and upon the instrument, if liable to duty, being stamped with the proper duty cancel and allow as spoil the stamp so misuse. And according to Section 59 on allowance, how to be made, in any case in which allowance is made for spoiled, unused or misused stamp, the collector shall give in lieu thereof the same value in money. In the case Brentwood Sedia Berhad versus Lembaga Hasil Dalam Negeri and ANOR, the applicant had entered into a sale and purchase agreement with menang kuasa Sedia Berhad in respect of a piece of land. The solicitor had sent the executed memorandum of transfer duly executed by the vendor to the applicant but was unable to have the property transferred to it on account of a fraud committed on him by its solicitor, is not entitled to claim the refund of the duty thus paid. After having sued both the vendor and the solicitor, he entered into a consent judgment with them and voided the SPA. The issue here is whether the stamp duty can be refunded or not. The judge finds that the application does not fall within Section 57 FI of Act 378 and the application is caught by provision A and B to Section 57. Therefore, the judge considered opinion that decision is not illegal or irrational and the application is hereby dismissed with cause. And in another case between Galaxy Energy Technology Sedia Berhad versus Timbalan Pemungut Duty Stamp Malaysia and ANOR, the appellant entered into a sale and purchase agreement with Tenancies Builders Products Sedia Berhad to purchase a piece of land. The balance of the purchase price was to be paid within a period of 19 days. The appellant paid the assessor's duty stamp at RM78,600 but failed to pay the balance of the purchase price leading to the vendor to terminate the purchase agreement. The vendor also forfeit the deposit and the earnest money and requested that the MOT and the original document of title be returned to it. The appellant therefore applied to the collector for a refund of the stamp duty paid pursuant to Section 57 F3 and or 4 of the Act. The collector rejected the application on the ground that inability to obtain a source of financing to pay for the balance of the purchase price is not included as a ground under the Act for a refund of stamp duty. The appellant thus applied for a judicial review of the collector's decision. The issue here is whether inability to obtain financing is an inability under Section 57F4 of Stamp Act 1949. The High Court dismissed the application. The appellant appealed against the dismissal. The appeal was therefore incompetent and accordingly Court of Appeal dismissed it. In another case between Koperasi Serbaguna Kebangsaan Berhad versus Pemungut Duty Stamp, the plaintiff is a cooperative society incorporated under the Cooperative Society Act 1993. The plaintiff purchased a property therein described for a total purchase price of 1.2 million ringgit and plaintiff solicitor submitted the appropriate form to the defendant for the adjudication as to the proper stamp duty under Section 35 of Stamp Act 1949. The defendant assessed the stamp duty payable on transfer of the property to be a sum of 30,000 ringgit. The plaintiff on 10 October 1995 paid the said sum of 30,000 ringgit. On 6 August 1997, the plaintiff discovered that under Section 35, First Schedule, Para 5 of the Act, the plaintiff being a cooperative is exempted from paying any stamp duty and sought for a refund of the same. By a later date on 9 October 1997, the defendant rejected the claim. The issue here is whether the stamp duty can be refunded. The plaintiff's application to get refund on its stamp duty is dismissed with scorn. Now we will move to the next subtopic, which is condition for granting allowance. According to Section 15A2 of the Stamp Act, provide relief from stamp duty in the case of a transfer of property to achieve greater efficiency in operation between associate companies on any instrument if the collector of the stamp duties is satisfied that the following conditions are met. Firstly, the effect of the transaction is to transfer a beneficial interest in the property from one company with limited liability to another company and the company are associated. Secondly, a third company with limited liability is the beneficial owner of not less than 90% of the issued share capital of each of the company. And lastly, the transferee company must be incorporated in Malaysia. There is also time limit for claims within a period of 4 years from the date on the stamp certificate, the date of young trained farmer acquired the required educational standard, and lastly, the date the local authority acknowledged your commencement notice or 7 days notice for residential development stamp duty refund scheme. And for within 3 years of the date on the stamp certificate if claiming a refund on certain instrument combined with a building agreement for a dwelling house or apartment, and certain lease combined with a building agreement for a dwelling house or apartment. We will move to the last subtopic, which is penalty. According to Section 47A1, penalty for late stamping stated that an instrument which is not stamped within the period specified in or under Section 40 or 47 may be stamped on payment of the unpaid duty and a penalty of 25 ringgit or 5% of deficient duty, whichever sum be the greater, if the instrument is stamped within 3 months after the time for stamping. 50 ringgit or 10% deficient duty, whichever sum be the greater, if the instrument is stamped later than 3 months but not later than 6 months after the time for stamping. And lastly, 100 ringgit or 20% of deficient duty, whichever sum be the greater in any other cases. And lastly, for the stamping of instrument after execution, Section 47, according to Section 47, any unstamped or insufficiently stamped instrument not being a cheque or promissory note drawn or made within Malaysia may be stamped after execution on payment of the unpaid duty if the instrument is presented for stamping within 30 days of its execution if executed within Malaysia, or within 30 days after it has been first received in Malaysia if it has been executed out of Malaysia. That's all from my group. Thank you.